Welcome back. We start with section 142. When they must not be asked. They means what? Leading questions. When they must not be asked. When can leading, when should leading, because when they must, so you should take it as should. When should leading questions not be asked? They should not be asked in cross examinations. We have already discussed this, so I don't think there is any need to tell you again. Okay, just now in the previous section I was telling you about this. In the cross examination, leading questions should not be asked. Why it should not be asked? The logic is we should not give any clue for the other party to escape from the hands of law. Understand? See, whatever are the defense being produced, we have no idea what it is. Only based on the balance of facts, judge says, yeah, okay. That's it. But we don't know actually what happened and all those things. So we should not be a contributing factor to the to such escapism. That's all. Okay. Then we go to section 143. See, one more thing what I would like to tell you is they should not be asked in cross-examination except where it is introductory or explanatory in nature. Understand? Where it is introductory or explanatory. For example, as I told you, we take up the same example of alibi. If I ask the person, you were not in Bangalore, where were you? That will not automatically become a leading question. I am only trying to introduce and explain. I am helping the other person to explain where he was, what he was doing, while introducing the person to what else was he doing. That's it. Okay, so it can either be introductory in nature. See, if he is showing a document, then I can ask him, what document is this? That will not amount to leading question. Is this a rental agreement? I can show it. Is this a rental agreement? Then he will say, yes, this is a rental agreement. See, for example, when we take up the check dishonor cases, dishonor of check cases, we show the check to the person. Is this the check on which you signed? Then he will say, yes, this is the one on which I signed. Otherwise, while examining the accused, we say, examining the complainant, we show the check and say, is this the check which the accused gave it to you? And then the complainant says, yes, this is the check. See, even though these are all comes under the leading questions, it comes under the category of introductory and explanatory. Understand? So, such questions, even though they are leading, will not hamper the process of law. Therefore, we can ask questions, leading questions, which are introductory or explanatory in nature. That is, the answers given will be introductory or explanatory in nature. Understand? Next, we go to the next section, section 143. 143 speaks about when they may be asked. We have already again discussed this. It may be asked in the examination in chief. Okay? Then we go to section 144. Evidence as to matters in writing. Evidence as to matters in writing. Who can give the evidence? Again, we have already done this. The latter part is more like a revision, right? So, who can give evidence as to matters in writing? Who can give evidence? Anyone who has? Of what? Anyone who has special knowledge of the document. When we are talking about special knowledge of the document, what are we looking at? It may be any attesting witness. It may be anyone who was present while the person wrote. You remember Indian Succession Act? While the person dictated. I was telling you about the defense personnel. They can just dictate the will and the person who is sitting next to them can just write it down. You remember that? Okay, so that comes special knowledge. Anyone who has special knowledge. It can otherwise be experts. It can otherwise be anyone who knows the handwriting of the person. Anyone who knows the signature of the person. Identify. Anyone who knows the contents. Anyone who has been an eyewitness. Anything. Okay. So what is needed is anyone who has special knowledge of the document. It can even be a person in whose possession the document is. He need not necessarily know what the document contains. Certain people, if suppose A has given a document to B and B doesn't even know what is there in the document. We call upon executors of will and all. I'm just giving you an example. Suppose B is the executor of will and he doesn't even know he is the executor. But the will be in his possession. So upon the death of the testator, the B will open the document and then get to know what is there. But till then he may know, he may not know. Am I right? Because it is not necessary that testator should tell B what is there in the document. B can open it. There is no this thing saying that he should not open the document and all that. But if he doesn't know also, there is no problem. If he has possession of the document, it is automatically believed that he knows about the document. Therefore, he can be called upon to give evidence as to that particular document. Okay, we can even talk about the public authorities in whose possession the public documents are, right? So they will look at the document. If you have seen any of the evidences, we can take for example police officers. They have so many cases, they have so many responsibilities first of all. On top of that, they have to come to court and give evidence regarding every matter, right? Investigating officer. So investigating officer, how many cases will he remember? It's very tough. So what will they do? They will take the papers on hand and then they will see some investigating officers. I will never generalize all these things. Some of them look into it and say, yeah, I know this is the case. Once they get a clue of what it is, then they will tell out all the facts of it. Right? This is as far as police officers are concerned. Other public authorities, if you can take up the example of municipal corporations and all that. Is there a birth certificate belonging to so and so person's name? They will not know because there is so much more than 1 billion population now, right? So every municipal corporation person will not know every person who has been registered as having taken birth. So what they will look at? They will look at the public document available with them. The entry in the register, birth register, death register. They will look at the birth register, death register and say, yes, Your Honor, this person has been born on this date at this in this hospital. The person has passed away in this hospital at this time on this date. Right? So that is how you have to think of. Other than that, all this comes into, even then they are all deemed to be persons having special knowledge. Understand? We move on to the next section, that is section 145. Section 145 speaks about cross-examination as to previous statements made in writing. Cross-examination as to previous statements in writing. It's not only criminal cases, even civil cases get this. What you have to see over here is cross-examination of previous statement. It is not the present statement. So what do you gather? Evidence can be of present statements, previous statements as well. Understand what are statements? Oral, written or electronic, right? We read it in the very first beginning of the Evidence Act. So cross-examination as to previous statement made in writing. So who has made it in writing? Say suppose B has given something in writing. Okay? Then he may be asked the question as to You wrote a document. Do you remember that? Okay. You wrote a document. Do you remember that? Can you tell me the contents? Were you the person who wrote it? See, for example, in civil matters, gift deed, right? Gift deed is very common. They will execute the gift deed and say, no, Your Honor, I want to cancel, I want to revoke. Okay? So it can be revoked, that's not a problem. But where there has been revocation of gift deed and then the other party comes and says, how dare you revoke it? And the person goes to the court as against the revocation, the cancellation of gift deed. Then this may crop up. In that case, this gift deed, which probably is dated around 8 September 2012, say for example, this may be asked. Suppose the person who executed this gift deed comes to the court and he is being asked, were you the person who executed, are you the donor? Then he will say, yes, Your Honor, I had executed a gift deed in favor of the donee, but this is what happened, therefore I had to cancel the gift deed. Some reason will be there. Even though it is out of natural love and affection and all that, there may be some problem, or there may be a release deed and later he may come to court claiming that no, I am not the one who wrote the release deed. I don't even know there is a release deed. If it is not registered, that's why all these things have become compulsorily registrable. But in case it is not registrable, will you have so many examples? Am I right? These are all at least compulsorily registrable and you can revoke and all these things. Power of attorney, you can take up anything. Or you can take up even the entries in the books of accounts which we are doing some time back. You can take up even those. Were you the person who wrote the accounts? Yes, I was the one who was maintaining accounts in so and so company at that particular point of time. Then come on, answer me all these questions. Right? So in case we catch hold of that person, we can ask him questions regarding whatever he has made in writing during the previous period of time. Clear? We go on to section 146. Questions lawful in cross-examination. Questions lawful in cross-examination. What are, you have 3 points over here. That which clarifies the veracity of statements, discovery, whichever helps in discovery. Number 3, questions lawful in cross-examination. Anything which tests the veracity. Anything which tests the veracity. What do you mean by veracity? The genuinity. Truth. The genuinity of a document or a statement made orally or by way of electronic record. If there has to be a test to test the veracity of the statement made by any party, then that may be asked in cross-examination. I say that this is yours. Okay, this is how we put it, right? Then he may say yes to it, he may not say yes to it. When I have to test the genuinity of a document or an oral statement made by the person, then I can pose such question in the cross-examination. Understand? Saying that whatever you have, the statement that you have given in the previous case or in the previous examination in chief, I say that whatever you have told, the contentions in the examination in chief, paragraph number so and so is false. Just to test the genuinity of the statement. Next, discovery. Discovery of the person. Who he is, what he is doing. Is he really the person whose right has been snatched away? Is he really the person who is liable? How do we get to know all that? Only through cross-examination. So if I am the person, see, if we will take up the dishonor of check case, it's very easy. Other than that also you have all the cases which test the same, right? So if a person says the accused counsel, he will come and cross-examine the complainant and he say, my client is not the one, the accused is not the one who has given the check to you. He has given the check to so-and-so person for so-and-so obligation which is already discharged. He did not give the check to you. It is not meant for you. You have taken a blank check from somewhere. I don't know how you took it. But you have taken the blank check where he has just signed it and you have filled in all these details. Then the complainant will say, no, I am the person. This is how the transaction took place in relation to which the accused had given me the check. Am I right? So when so much explanation is going on, we already read, leading questions should not be asked except where it gives an introductory or explanatory answer. So when I am saying you are not the person to whom it was given, he will say no, yes, it was given to me. It's a leading question. But it is allowed because it gives the discovery. And also in the previous section when we read, whichever is introductory or explanatory, it can be asked in, right? So this is what discovery of the person. Is he really the person to whom the check was drawn on? Is he really obligated? Is the accused really obligated to the complainant? So these are all the questions which crop up. To discover that, question can be asked in the shaking the credit of the person. I put to you that you are not at all the person who has. You yourself don't have money. Then how can I say that you are the one who invested in so and so company and you were cheated? How can you give such a contention when you yourself do not have any money to invest? I am trying to shake the credit of the person who has come in saying that so and so person has played fraud on me. So I am entitled to so much compensation. Okay, you can take up even civil cases. This land belongs to me, Your Honor, but he has taken up my land. Tell him to give it to me. So I will say, no. You do not have such a big land. Your land is only so much. This person's land is so much. In fact, you are the one who has encroached upon his land. Understand? So shaking the credit of the person. Why? To know the real fact. It is related to discovery of the person. Okay, but just like that we cannot question the character or anything like that. See, there are always riders. Just like that we cannot question the character of anybody or anything like that. Right? We can only ask selected questions to prove our case. That's it. Next we go to section 147. Section 147, when witness to be compelled to answer. When will witnesses be compelled to answer? When will they be compelled to answer? When it is seen that, see, I was just looking at the section number. See, in section 132, it says, what does it say? Witnesses should answer. They should not escape. Answering any questions just because it will criminate them. You remember? We read it. That is section 132. Okay. So, where the witness feels that he should not answer a particular question. Why? Because that answer will incriminate him. I have already explained to you under section 132. Kindly refer to that. So just because it will incriminate the witness cannot escape from answering. The witness should answer. If he is not ready to answer, the court has all the power to compel him to answer. Clear? Next we go to the next section, 148. Court to decide when question shall be asked and when witness compelled to answer. when question shall be asked and when witness compelled to answer. See, the court has all the powers to ask questions. When can the court ask questions? This is the question in this section. This is what we are dealing. When does the court ask questions? Whenever it deems fit to ask questions. There will be cross-examination, there will be chief examination, there may be re-examination. All these are to one side. But when can the court itself ask questions? Court will ask questions to either party or the witnesses when there is need for asking the question. If the court thinks that, okay, let me ask this question to so and so witness, then the court has all the power to ask the questions. Okay, so when it deems fit, this is a common this thing. Second one. Okay, so whenever the court deems fit, it will ask questions. But when witnesses shall be compelled to answer, whenever the person escapes from answering. When the person escapes from answering a question just because it will incriminate him, court can compel the person to answer. Okay? Or when there is an improper question also, the court can interfere and put it in a proper manner. If I am asking some questions, then immediately the court can say, no, don't ask that question. It is not relevant to the facts of the case. Or put it in a nice way. Don't talk like this. Don't ask questions like this. Court has the power, understand, to give directions to all of us as well as ask questions to the party or the witness. Okay, so now when we are talking about this, when witness can be compelled to answer, when he escapes from answering just because it will incriminate him, or when there is an improper answer, incomplete answer, an answer which is necessary to decide the facts of the case. See, only when the witness or the party gives a particular answer, then the facts of the case will be in a particular sequence. In that case also, the court can tell that you should answer this question, otherwise the facts of the case will remain undecided. Understand? So these are all the questions. These are all the situations in which questions may be asked by the court, and the court also has the power to compel the party or the witness to answer. We go to section 149. Question not to be asked without reasonable grounds. Do we know this? Yes, we know. Just now I told you, if I am asking a very, maybe a very personal question which is not needed, more than being a personal question, if it is not needed for deciding the facts of the case, facts in issue and or relevant facts. Whenever a particular question need not be asked, but still I want to show my knowledge. So what I do, I prepare around 20-25 questions, which includes those which need not be asked. Okay, then the court will say, please don't ask all these questions and waste the court time. Right? So when questions not to be asked without reasonable grounds. So this is one thing where we have to keep our mind open. See, you as a judge should know which questions may be asked, when it may be asked, when it may not be asked. Understand? So keep your minds open and then deal with the situations accordingly. So some of the questions we have already seen in 148 section. Okay, you can include that also in section 149. Then we go to section 150. Procedure of court in case of question being asked without reasonable grounds. So what is the procedure of the court when the question is being asked without reasonable grounds? What is the procedure? The court can shall interfere. The court shall interfere and give directions to the party or the party advocates to ask the relevant questions. Okay. Other than that, the opposite party advocate can also object. The opposite party advocate can raise objection saying that, Your Honor, this is not at all needed for the case. Why is this party advocate asking him questions like this? Okay. So, what are the procedures? First is, the opposite party may object to the raise objections to the questions being asked without reasonable ground. There is no reasonable ground at all. Then why should I ask a question? It is not necessary. Suppose where the person is not at all contending an alibi, I go around asking that person about questions regarding alibi. Is it necessary? It is not at all necessary. Right? So, the opposite party may raise objections and also the court may interfere and stop me from asking such questions. We go to section 151, indecent and scandalous questions. Indecent and scandalous questions. Indecent and scandalous questions means what? Anything which is not decent to be asked in public. Understand? Anything which causes, see, indecent means anything which is not decent. But what is scandalous? Anything which may assail the character. Scandalous. It may assail the character of the party or the witness. We find all these things especially in the sexual offences cases. Right? So, we should not be asking indecent and scandalous questions at any cost. Okay? Then section 152. Questions intended to insult or annoy. Section 152. Questions intended to insult or annoy. We cannot pose any questions which will cause insult to the party or the party witness or annoy the party or partner. It can be either party, okay? All these are all neutral provisions of law. They do not belong to only the complainant or the accused, plaintiff, defendant, nothing like that. Understand? These are all general provisions. So, it should not insult. Insult means what? It should not put the person down. I know you are like this. That's why this happened to you. I know you are like that. That is why he spoke like this to you. You know, all these are all like insulting. What is annoy? Annoy is irritation. It should not cause irritation. So, no questions should be asked in a manner which will insult the person or irritate the person. Understand? Just like that, if a person gets irritated for each and everything, then that is not logical at all. But what I am trying to say is, the questions themselves should not be to insult or annoy the party or the party witness. Next, we go to section 153. Section 153. Exclusion of evidence. Exclusion of evidence to contradict answers to questions testing veracity. Okay, so here what is written over here? Evidence of exclusion of evidence to contradict question contradict answers to questions testing veracity. Okay. See, this what we are talking about, answering to exclusion of evidence. To contradict answers to questions testing veracity. Sometime back we saw that questions testing veracity may be asked in cross-examinations, right? So we saw that it can be asked in cross-examinations, questions testing veracity. It can be asked in cross-examination. So contradict answers. Obviously this also comes in shaking the credit. You remember? We read all this in the previous sections, right? So exclusion of evidence to contradict answers to questions testing veracity. I have posed a question testing the veracity of a particular statement in the cross-examination, right? But when I am trying to produce some evidence, it should not injure his character. It should not shake the credit of the person. See, these are all basic. Why we write all these things? It is only to respect the other human being. Law does not